Vallow Daybell is mad as hell, y'all. Pissed. She is demanding that the judge step down. It's crazy as hell, y'all. East Idaho News was talking about it. Make sure you go subscribe to his channel. It's pinned down in the description. Let's take a look here. Oh my God. Oh, and make sure you like the video here. And subscribe if you're new. And let's check out Vallow Daybell getting mad as hell.
Round 2 of Lori's Arizona case. She does not want Judge Justin Beresky on her trial. Which is kind of interesting that she's filed this motion. That's what we're going to talk about tonight. and I want to answer some of your questions. So please put them in the comments below.
Yeah, she's all about it. He's so biased.
But Lori has been insistent all along that her trial happen, that she has a speedy trial and that it gets done. She has demanded that. But now she's asking for a new judge to come into the case, which would postpone her trial. She filed this motion.
Hell.
We got our hands on it today, and let's just jump right into it. Now, you might recall at the hearing last week, well, I guess now 2 weeks ago, at the tail end of that hearing, this is what she said to Judge Beresky.
Your Honor?
Yes.
I'd have to ask that you would recuse yourself from the obvious personal bias that you have against me and send us to master calendar for this scheduling of a trial.
And what personal bias is that?
Oh, God.
A lot. Obviously, the personal bias that you're showing right now and that you've shown on the FTR several times during the trial.
Okay, well, I don't have any personal bias, all right? I've over-accommodated you on when you have to disclose things.
On everything?
In fact, your expert should be summarily precluded today, and I haven't done that. All right? So
You denied every single one of my motions for a year and a half that I've been here. Every single one of my motions has been denied. And have any of those motions not have merit?
Yeah, because they're all crazy. They have no legal basis, is what he says.
You've denied every single motion.
How dare you!
I think I was here this morning about 15 minutes ago when I granted your motion to meet with your attorneys over the lunch hour. I have granted other motions of yours. Okay?
That's the first motion that you've ever granted.
Well,
in my behalf.
file motions that have a legal basis and I might grant them.
So you're saying none of my motions have had merit?
Not many, no.
And none of the motions that my first team, you denied every one of my first team's motions, you denied every one of my second team's motions, and now you denied every one of my motions until today.
I haven't denied every one of your motions.
Every single one of their motions was denied, every single one of the second team's motions were denied, and all mine. So you didn't come into this with any bias against me in the first place?
You need to back up off that mic, Lori. Holy hell. That's a hot mic.
Again, file a motion that has legal merit, okay?
And none of my attorneys ever filed a motion with any legal merit?
They filed a motion on your behalf, the first team, to preclude media coverage, and I issued my ruling according to the law, all right? They filed a motion to have you dressed out, not in jail clothes during hearings like this, okay? That was not based in law. I denied that motion. So I've ruled on the motions as required by law.
Without any kind of a conclusion of law in them, just denied, 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 denied. Does that not show a bias and a prejudice against one single person?
No, it just shows that you're crazy as hell and everything you're asking for isn't real.
All right, are you done?
You what? That's the best part. Are you done? Are you done? Because I want to deny even having to listen to this.
Are you not going to recuse yourself?
No, I'm denying your motion. Anything else?
So he denied the motion. That didn't stop her from filing a paper motion. And here is what it says, or at least part one of it. I'm going to try to zoom in here so hopefully you can see that. It says the defendant Lori N. Daybell files this motion and her affidavit is required to show that the Honorable Justin Beresky has a personal bias or prejudice against her. As a result, the defendant cannot receive a fair or impartial hearing or trial before this court. Based on the affidavit, the defendant respectfully moves that the Honorable Justin Beresky proceed no further in this action and that another judge be assigned to hear the case. Now, many of you, I know, have commented that you believe the judge has been overly fair to her, a little too fair, some of you have said, in the fact that he's, told her multiple times that he can't give her legal advice, but at some points it does appear that way, that he is kind of helping her along in a way. I have not observed that. I believe that the judge has been fair and he has been out of the spotlight, you could say, not trying to persuade things one way or another. But this is what Lori, so she attached an affidavit to her motion. And this is what she says. I, Lori Daybell, being duly sworn, say, Mrs. Daybell has made multiple motions for Judge Justin Beresky to recuse himself from her cases. He has refused. And he willingly violated the Code of Judicial Conduct, Canon 1-2, manifesting bias, prejudice, and cannot be impartial in the defendant's case. On May 14th, the defendant's case are in the worldwide media.
So because he didn't do what you want, he come on. You didn't do what I want and you didn't grant all of my motions. So you're manifesting bias. You're being prejudiced against me.
How dare you?
No, Lori, you're just crazy.
Network.
Not everybody's going to do everything that you want all the time like you thought the first, 86 years of your life, or however old she is.
Okay, let me stop there.
50 something maybe, actually. I have no idea. How old is Lori Vallow? Put in the comments.
I got to reread that. On May 14th, 2025, the defendant's cases are in the worldwide media networks. Justin Beresky refused to recuse himself in direct questioning by the defendant. The judge proceeded to breach his duties of the Codes of Judicial Conduct, Canon 1-2, by further commenting with opinions of the defendant's prior two groups of counsel, the defendant's advisory counsel, and the defendant's motions that he has denied without cause or decision to support his denial of requests. A judge should have recused himself related to the merits of their own ruling. In regard to complaint of judicial misconduct, a judge commits error of laws in the process of reaching discretionary conclusions in abuse of discretion. On the May 14th, 2025, court proceeding, Judge Beresky's behavior and judicial acts fall within the scope of, quote, bad faith. The acts were intentionally committed, and the judge knew or should have known that his actions were beyond a judge's lawful power and without lawful power of judge, but for corrupt purpose, which includes any other than faithful discharge of judicial duty. In Judge Carroll, she quotes,
"Don't you already have a life sentence, Lori?" Maybe, you know what? Maybe that's what it is. Maybe she's just doing all this crazy stuff. She's bringing up all these kinds of motions. She's doing like, the judge is biased because she knows it's over. Do you know what I mean? Like, when this is done and when all this stuff is over, that's it. Like, you get to sit in a cell and just spend the rest of your days, isolated. So she's like, I'm just going to drag everything out and go crazy and do this and do that. Maybe it's just all for attention because she knows that once this is done, it's done.
Case law, the motions that the defendant, or she quotes another case, I should say, the motions that the defendants prior to legal counsel teams, the defendant and her current advisory counsel have advised for the defendant to file for evidence and further motions of requests are crucial to the defense preparation. Witnesses, experts, evidence, proof of innocence, cross-examination, rebuttals, and foundation to the defense, all of which Judge Beresky has deprived the defendant of access to the evidence. A judge abuses his discretion in controlling discovery. Judge Beresky crossed the line of neutrality when he misemployed his powers, when he assumed role using his judicial powers to advantage or disadvantage a party unfairly, thus giving the impression that this court has opinion. Improper judicial intervention results in prejudice. The, quote, facial expressions, attitude, demeanor, and statement.
The facial expression.
You what?
How dare you look at me like
How
that?
dare you?
Your attitude and demeanor are biased, sir. Lori. I'm telling you, to me, it seems like she's doing all this because once it's over, it's over.
Deprive the defendant of a fair and impartial hearing, violation in conduct that is prejudicial to the administration of justice. A request for presiding disciplinary judge is being made on Judge Justin Beresky. A request for presiding disciplinary judge is being made on Judge Justin Beresky. I'm not sure what that means. On May 14th, Judge
I don't even think she knows what it means.
Beresky refused to apply or understand the direct guidelines of the Maricopa County Sheriff's Office own attorney, Maricopa County Attorney's Office Civil Attorney Joseph Vigil. On May 20th, 2025, Maricopa County Sheriff's Office response to removing restraints during trial on page 3, quote, without any restraints in the courtroom, Madison County Sheriff's Office would recommend an unarmed detention officer and an armed sheriff deputy in the courtroom. This goes back to the fact that Lori has said she doesn't want to wear the belt, the rack belt, and she wants to just have an extra deputy with her. The sheriff's office gave some recommendation to the judges to keep the courtroom secure, to make sure Vallow Daybell doesn't take off. The judge issued his ruling and said, I mean, you can give recommendations all day long to a judge. They're going to rule how they're going to rule. I was just watching Judge Judy a minute ago. She's going to rule how she's going to rule.
That's true.
So while the sheriff's office might say this or that, the judge is going to say, no, this is how it's going to be. Lori's upset by that. About the belt is visible on the defendant and has fallen off the defendant in prior trial proceedings. The motion was denied by Judge Beresky.
My belt keeps falling off. We'll put it on better.
Apparently, at one moment, the strap of the belt in the last trial came down so the jury could see it. I don't know about the belt falling off the defendant in prior trial proceedings. I never saw the belt fall off the defendant, but perhaps it did. Anyway, she goes on to talk about affirmative acts or omissions performed by the judge. Judge Beresky,
with what she did, y'all, like what she's convicted of doing, what we know she did in Idaho. I mean, you need to be wheeled in to the courtroom like the dude from Con Air. What was that guy's name? Yeah, this dude. This guy right here. Show it. Yeah, that. Like that's what you need to be brought into court looking like with what you did to those kids. That right there. That's how they should bring you into court every day. Acting crazy as hell.
The sheriff's office
unbelievable
motion or recommendation, she says, violated and was done on bad faith. And then she goes on to talk about the speedy clock. As a defendant, you have X amount of days to have your trial. She has not waived her right to a speedy trial, much like Chad did in Idaho, and that's why his trial was able to be held later. Lori has not. So she's saying that the speedy trial clock has exceeded the maximum days. She brought this up. She's brought this up a few times, and the judge told her before that we were supposed to be in trial, the other trial right now. That trial was supposed to wrap up just last week, I believe, or this week. And then he said, you can't have two trials at the same time. You could ask the state to combine them, and the state actually kind of seemed open to that for a moment, but Lori didn't want that. So she's now saying that the judge, another reason he should be DQ'd, disqualified, is because, quote, the speedy trial has exceeded the maximum days. The act is violated, thus the case should be dismissed. Okay, so now she's going into the case should be dismissed. Dismissal without prejudice is not a toothless sanction for a speedy trial action violation. No continuance appearance may be excluded from treaty trial computation. A continuance period is not excluded from the speedy trial calculations. On Judge 9th, 2025, Judge Beresky in trial, which media networks aired his comment against the defendant. Okay, so now she's going into another area. She's talking about the judge should be disqualified. I don't know if she listed any clear and concise reasons in the beginning, but then she went on to talk
I doubt it.
about how her trial wasn't given in a speedy amount of time. So that's another reason he should be disqualified. Now she's saying he should be disqualified because of a comment he made in the last trial when the prosecution objected to a line of questioning about faith and Nephi, I believe. Judge Beresky said, quote, "I guess to the extent you're comparing yourself to those biblical figures, I will allow it." The statement in the statement to whatever the questioning she was doing with the witness. She goes on to write, Lori goes on to write, "This was a malicious act by Judge Beresky to the defendant, manifesting discrimination and religious persecution against Mrs. Daybell's religious exercise, belief, and practices. The comments compound the prejudice of an erroneous misunderstanding for the purpose of fundamental error. The defendant only needs to establish one prong to prove fundamental error. A judge who engages in improper behavior while on the bench is sanctioned, imposed, quote, unprofessional conduct, and violates a court rule." Under this, another rule, disqualification, one, grounds a judge must recuse himself for any proceeding while a judge expressed an opinion concerning merits, and on and on and on. The comment is order for dismissal. She says, "I am the defendant in the above entitled case. I am informed and believed, and based on information and belief, allege that the Honorable Justin Beresky, the judge before whom this case is pending, has personal bias against defendant LoriDaybell Daybell in favor of the state. A judge who manifests bias or prejudice in a proceeding impairs the fairness of the proceeding and brings the judiciary into disrepute. Facial.
Lori.
What the fuck?
Come on. Like everything she's saying, you're just like, what?
Expressions, attitude, demeanor, and statements deprive the defendant of a fair and impartial hearing, bias, or prejudice of judge. A judge shall not preside once affidavit is filed. The facts and the reasons for this belief that such bias or prejudice exists are statement of facts above. Signed, LoriDaybell. Okay, what's going to happen from here? The judge is going to hear this or rule on it.
Right.
And he could say, okay, I'll advance.
In about like 3 seconds, he's going to rule on it. He's going to be like,
what? What the fuck? I've spoken with a few attorneys today who say that there is, this is based on faulty logic, that really there's not much here. The judge could say, I received your affidavit, I received your motion, I'm going to deny it. If he really felt that she had a point or something, it could move up to another judge, and he could release the case. But again, if that happens, we're not going to trial on Monday, and I don't know if the judge is going to do that. This is going to be interesting because Lori obviously has some strong personal feelings against Judge Beresky, and now that the trial,
almost like she has a personal bias against him.
If she goes into this trial passionate about it, heated about it, you could see some interesting fireworks perhaps as the trial goes on. And I think the judge will take whatever comes with this. Now, this
You know what the judge is going to say? Hold on a second. I have a feeling, I just have a feeling. This is what I thought of. Like, the judge is going to stand there, and then I think that, like, just immediately, this is what the judge is going to say. Hold on. Look, this is what the judge, for sure, this is the judge. The judge is just going to go like this.
I really don't know what he said at the end of that sentence. I don't think he knows what he said either. Look.
has filed.
I have no idea what she said. I don't even think she knows what she said. This is crazy as hell. I'm out of here.
A response. And I just got it. I got into Arizona. I sent an email. I said, can you send it to me? I paid my $16 and I got the documents. They charge per page. That's why it was $16. So let me make this big here and you can read it with me. And this is how Treena Kay is responding to Lori's request. The state of Arizona, through undersigned counsel, responds to the defendant's motion to disqualify Judge Beresky. Defendant's motion should be denied since established any judicial bias, appearance of bias, or fundamental error. A defendant's motion to disqualify the judge heavily relies upon the fact that Judge Beresky has provided legal reasons to deny many of the defendant's motions. He sustained objections made during the trial, and he found no prejudice to the defendant when he excluded 18 days and scheduled this trial to begin on June 30th, 2025. So there's her kind of synopsis as to why it should be denied. The defendant previously incorporated her allegations of judicial bias in her motion for new trial. She also made oral argument to disqualify the judge. The judge issued a minute entry providing his reasoning for denying a new trial based upon the defendant's allegation of impartiality. On May 14th, the court put on the record his reasons for denying the defendant's motion for the judge to excuse himself. The court put on the record that he had no personal bias toward the defendant, that he has accommodated her requests, that he has allowed her additional time beyond that allowed in the rules to obtain expert testimony, and that denying her motions when they had no legal basis of not evidence of bias. And then they go on to quote some case law saying that, you know, why the judge does not have to disqualify himself. Defendant's arguments in support of judicial bias are similar to the allegations made by the defendant in another case. Defendant's motion to disqualify the judge should be denied since the defendant has not established any judicial bias, appearance of bias, or fundamental error.
Yup. Lori, she's just crazy, y'all. I mean, that it has to be. Let me know in the comments what you think. I think it has to be the fact that she's like, she knows that it's over after this. So she's going to try to do everything she can to just prolong everything as much as possible and just things to go crazy and people to talk about her. And that's it. Because after this, it's over. That's it. Donezo. Anyways, y'all like the video, subscribe if you're new. And I'll see you guys on the next one.